Good evening. This will be the work session for May 24th, 2022 of the Pinehurst Village Council. I've called the meeting to order. We have a couple of items to discuss tonight. The first is a kind of update and direction from council and from staff to each other about the NAC policy discussions we've had over the past couple of months. So we'll move to that item right now. Jeff Sanborn, my understanding of kind of where we ended up with the NAC last week was that there are some issues out there that are in the minds of some of the representatives, particularly as to how the documentation will work going forward. But with respect to that, I believe you said, and correct me if I'm wrong, you're intending to devise or to develop documents with respect to, I guess, all of our volunteers and how they sign on and commit to the different committees and commissions that they're on. Could you, and not all the council members would have heard that, nor the public, but can you explain that just a little further and how we would go about doing that?
And we do something like this for our primary boards and commissions right now, whereby we do a formal onboarding process. There's a specific checklist of discussion points that have to be covered. One of those is open meetings and public records. So, for example, our HPC, our planning and zoning, and BOA folks get that counseling when they start as a volunteer with the village. But then we also have them sign the initial, but they're basically signing off on an acknowledgement of their expectations. And I think that the idea is to have a similar process, something like that for the NAC.
Yeah, in fact, it was Kelly Chance who reminded us during that meeting that the whole onboarding process is kind of what the intention is to do here. So yeah, that was very helpful. I wanted to thank her for participating in that way and talking a bit about what the documents might be. But it would be some sort of a new document, I guess, not just the volunteer application form that we would have developed potentially over the summer, and that would apply to all of the volunteers that we have in the different committees, commissions, NAC, whatever.
I don't know necessarily that it will be the same form for everybody, depending on, what type of volunteer work they do for the village. Some topics may not be germane to some of our volunteers, whereas other ones certainly are. So I don't think we've crossed that bridge and done that analysis yet, but yeah, we would like to have some sort of a similar process for an experience for all of our volunteers.
Okay, good. Now, Jane and Pat were at that meeting as well. Liddy, you were not there, I don't think. But are there other parts of that discussion that either Jane or Pat or Jeff Sanborn yourself want to bring the rest of the council up to date on, and then we'll kind of figure out our time frame over the next few months?
One of the primary things we wanted to get from the NAC was their feedback on the proposed geographic framework, and my impression from what conversation we had with the NAC about that geographic framework in both meetings that we talked about that with them was that they generally were accepting of that proposed geographic framework with one or two comments from different members.
Yeah, I've had one comment a couple of times on this, and that is the lack of not using the phrase downtown to signify where downtown is represented by. And at first I wasn't sure how important that was, but the more I think about it, I think it's not so important maybe to the NAC, but I think it's important to the sort of downtown merchants community that they don't have a name or a title there that they right away know that's who we should go to on the NAC. Right. So wherever that line of demarcation is, I think it's east or west now. I don't have the map in front of me. I think that's how you broke it down.
Maybe we need to revisit that line, because I think most of it's in west, but some of it's in east, and that's,
Well, maybe that might be the issue, but it'd be good if there was one, it was in one area, and that area was either downtown/east or west/downtown, something like that. I think that would end any of the hesitation on some folks as to who's where and what does that mean. So that's my only comment. I'm fine with the onboarding. I think that obviously the sooner the better. I think we do now have the names of the NAC folks on our website. I believe I saw them. And, but we still need to address that with the other advisory committees to make sure they're all listed publicly for the sake of transparency. That's all I have. Thank you.
Okay. Jane, any additional comments about what you were hearing, or?
No, nothing other than that. I agree with Pat.
Is there a question to Lydia? Go ahead.
I like the geographical drawings. I think that's something that's been weak for a while. One thing I'm hearing, but you guys were in the meeting, so I don't know if they're really articulating in the meeting, is the heartburn over their emails being discoverable, or their emails being subject to. And, one thing I was thinking about, Jeff, and you might remember this from several years ago, but I think council might have appointed a subcommittee, and then I think it was determined that that subcommittee was not I'm trying to find some wiggle room. That subcommittee was not a public body, and therefore they weren't subject to the open meetings laws. Oh, you're smiling like you know what I'm talking about. But I wondered if there's just some give somewhere. And let me back up a second. Even the comment was made back then that it'd have a chilling effect if those subcommittees were subject to open meetings laws. So you wonder if there's some wiggle room where maybe, if that really is heartburn for them, that their emails are not subject to public records. You're nodding. I mean, is there wiggle room? Are you hearing concern from the members of NAC that their emails are subject to the public records?
The first thing you
Been
hear
brought
is,
to their attention. I'm not hearing any concern about it. There may well be, but on the other hand, excuse me, Pat, from my point of view, as I think I've written on this, there are two or three elements I think we need to work out, not only for the NAC but others, and that is, I don't think we should have personal information, phone number, residence, whatever, in the on the website. That I think to list the names, and if it happens, and I think Jeff has this idea, if it happens that in the NAC case, if they can have a generic email that just is for that purpose, that may help solve the idea of having a personal email out there. Isn't that one of the ideas we're looking at on how to help organize the NAC?
that's exactly right. And then for example, for organized neighborhoods where the representative comes and they're representing, for example, the property owners association or what have you, if we could just get the permission from that organization to have that contact email listed on the website, then we could do that as well. I share John's concern about public or personal information being on our website. And in particular, Darren and I and others had conversations about, in particular, our HPC and our BOA members, and we, because of their roles, we don't want the public contacting them. That sets up inappropriate things. So,
but the public should know who they are,
And
and they should know the length of their term.
right, but
That should be on the
contact
website.
information is the.
Well,
yeah.
I'm not,
Yeah.
the contact information, I
Right.
don't care about their name, the length of their term. I think that's sort of the fundamental information that the citizens need to know about.
But to Lydia's comment, yeah, I think there are one or two members that are a little bit nervous about this public records thing, but it is a public body. I think the situation you're describing that we went through previously, I think we ultimately learned that we were wrong.
Okay.
And we disbanded that body because it
It's a
didn't work.
public body. Well, and it may not be that big a concern But it's something I've heard, and y'all have been in the meetings, so you know whether it really is a concern. But I think what I'm hearing is that some of them are a little bit nervous about a public records request, and they have to turn over emails.
Well, I
No,
think,
it's happened exactly 0 times.
right.
Okay.
Well, I think that the best word I would use to describe it is that they were surprised when they heard this. Okay, I am concerned didn't set in immediately, but there was a surprise factor for a lot of people because they never suspected it. They're not working on government computers, they're not paid, they're volunteers.
Goes to the onboarding thing. I mean, if we
Yeah.
just identify the requirement up front, it wouldn't be such a shock to people, I think.
I agree.
On this issue of the email, do we have a sample out there somewhere where that's being done? I mean, I think it's pretty simple, but are we trying to follow the example of another part of village government that's doing that, or another?
You mean the
something we've
generic
heard?
email
Yeah,
account thing?
yeah.
We have, no.
It's
we've
pretty
not.
easy to do, I think, but, okay.
We're fairly certain we can make it work, but I don't think we have an example to work off
Okay,
from.
all right. Lydia, did that answer your questions?
I guess I just wanted to bring it up as a concern. You say surprise, something I'm hearing, but I'm not in the meetings to hear it being discussed. I don't know how big a concern it is, but because it's been articulated to me, I wanted to bring it up.
Yeah, I think that, we should all be very concerned about transparency. It comes up a lot, right? We hear it from members of the public on various topics. These folks, our volunteers are members of our village governance structure. And transparency is important with respect to them as well. So that's where the public records law thing comes in. Like I said, in my experience here, we've never had a single public records request for communications to or from one of our volunteers. It doesn't mean it can't happen, but it's not likely. But I think people need to know that it can come, and ignorance isn't an excuse in public records law cases. So it's better that they know of the requirement ahead of time so that they can take appropriate measures.
Okay.
Pat, anything further?
Nope, I'm fine if we.
Jane or Jeff Morgan? All right. So Jeff Sanborn, then the plan will be, and we'll discuss this through with the last meeting of the spring with the NEC in June, in a couple of weeks, that during the course of the summer, these ideas of how the map works, how the documents are going to work, the emails, all that will be something we probably can work out during the summer. And in the fall, begin with the NAC to have this installed.
That's right. And I think that we can use this summer to start recruiting for those open
Yeah,
positions on the NAC as well and try to get things primed for next fall.
yeah. Okay, all right. Is that helpful to council to understand how that might come together? Hopefully will come together. All right. We'll move on to item number 3, short-term rental policy. I think we got a variety of things to go over here tonight, but let's start with Darren and where we left off with the matrix and the decisions we made 2 weeks ago and how we can proceed with that. And we have some other draft proposal information to review that we'll work through as well.
Since last we met, I have not been able to update the matrix that we were working on based on my notes from our meeting.
Darren, you need to bring that microphone up. Thanks.
As far as number 1, I think we ended up on the land use my recollection is the land use definition was define STRs as whole house as less than 30 days of consecutive rental. We were going to pull out this 14-day grace period because we can't, without a permit or a registration requirement, it's hard for, it's not enforceable. So we were gonna just define the STRs as 30 days or less. Jeff, you?
Well, let's not give up on the permitting requirement.
Well, I'm not giving up on a permitting requirement. What I'm saying is it becomes difficult without a permitting requirement. If we have a permitting requirement, it's easy to do that, the 14 days.
I don't know that a permitting requirement is required to carve out that exemption.
Well, we have to be able to know when somebody's
In other words, it wouldn't qualify as a short-term rental unless it was used for more than 14 days.
more than 14 days, yeah. It's just, we were trying to figure out how we would enforce, well, I guess that the enforcement will be really, it's somebody operating more than 14 days.
Yeah.
So that will really be the enforcement mechanism. We'll see that, we'll see an operation, and we'll know it, and we'll track it, and then we could, if it's prohibited in a district, then we could enforce. Any other thing on land?
Any other question on that? I think we've decided that before.
Then it really came down to the two of the major discussion points. One was allow in all residential districts, and I think we veered off to allow in multiple family, non-residential districts. And then there was the other, and we would allow it with the enhanced standards and regulations, meaning we'd have the occupancy caps, we'd have the parking, we'd have those things as part of the regulation. And then 3, the discussion was prohibit and amortize in residential single-family districts.
Darren, on 2, I thought we recognized that why would we allow it in residential but not in commercial or mixed use and therefore,
Yep.
Therefore, wouldn't it be better to say allow in all zoning districts where where residential dwelling units are allowed?
Yeah, we can rewrite it that way. We rewrite it to allow in all districts where single family or where residential uses are permitted, right?
Yeah, something like that, yeah.
That was my understanding also. Thank you, Jeff.
So that would include NC, that would include OP, that would include most of our districts.
The mixed use where you have residential and where
Correct.
the impact of short-term rentals would not be significant anyway.
That's correct. So that's all districts currently. So every district that allows for residential single family, if you go down this route with the enhanced standards, we would draft an ordinance that would allow that into the districts. Counter that with
Allow what into the district?
STRs. With the enhanced standards, correct.
It's one of the options, Pat.
Okay, you're trying to, I was confused. I was looking at 2, and then I looked at 3,
Yeah.
and so that's what's getting me going.
And then 3 is the complete opposite.
Okay, I see what you're saying. All right,
Yeah.
3 is prohibit, and there's 2 concepts in there. There's the prohibition concept, and then there's the prohibition and amortization concept. We could just prohibit and simply they would become non-conforming uses, but once you start to add in the words amortize for the discussion points, that really does beef up that prohibition standard. So those are really 2 things that you kind of got to talk through. Do you want to prohibit, and do you want to prohibit and amortize?
Yeah, and in that recommended language in number 3 in red, I would recommend making a reference to any time limit until we have had the opportunity to give you some analysis on that reasonable expectation to recoup investment requirement.
So what are you thinking on the not a 2-year amortization period?
Just remove it. It just say amortize. And we need to do some analysis on the time limit.
What type of analysis would we do? In other words, I'm trying to understand what the
Well,
equation is. We're picking, the 2-year one is one because it's been used
I don't know.
elsewhere.
I mean, for example, you might do a quick market research on how much the average short-term rental property owner invests in transitioning a residential property into a short-term rental property. And then you might do some analysis on what the average income stream looks like in a given year for a short-term rental. And you might compare that to what a long-term rental lease rate is, figure in taxes and all that stuff, and try to figure, there's not a requirement to get it exactly right. There's a requirement to do the analysis and have something to hang your hat on.
So Jeff, you're suggesting that the 2 years in the bottom red line, part of 3 there, we don't know that yet.
Don't know it yet, yeah.
So we want a chance to look at that and to look at some data for that.
Right.
Yeah. So for purposes of evaluating these 2 options, 2 and I think I called it 3B in our last meeting, right? And
You did.
it was written by Jane, I think, initially with these add-ons. So taking the 2-year out of there is something we would work through until a final ordinance might be adopted.
Yeah.
Now, I'm going to ask Jane, just, were there any other changes to this wording? I have some notes here, but they were just notes, not necessarily changes, that you felt we had made or you wanted to make to that, that wording there in the red 3B, I called it? I think it is exactly as we had it, but I just wanted to make sure.
Which number are we talking about?
Well, it'd be number 3 here on the matrix, land use. The underlying red material. That was your alternative wording from the text above it, right?
I have a version that doesn't have any red.
Well,
Okay. But.
it's
if
the
we're-
prohibit in all single-family residential zoning districts.
Right, right,
Correct.
which is generally what I was talking about before.
Microphone, please, Jane.
Do
Microphone.
we want to consider exceptions for homeowners associations that have deeded covenants which deal with short-term rentals and give them an opportunity to opt out because they've already got a program that works for them? This is essentially a protection for single-family residential. That, and then there's another question. Are there some properties that have historically operated as short-term rentals over a long period of years as opposed to being recent pop-ups that or areas of town where we would want to have some kind of an overlay or something that permits in certain circumstances and those are
Permutations?
the general rule is what I've laid out before, but
Yeah. Yeah, with regard to, those are permutations that I think you certainly can consider. They both create potential problems with regard to defensibility of your decisions in court, I think. the first suggestion about carving out an exemption for neighborhoods that have restrictive covenants, I guess I would put it this way. If you're going to ban or not allow short-term rentals in single-family residential districts because you have made the assessment that they are incompatible with single-family uses, why would it be different in an in a neighborhood that has restrictive covenants? It's either compatible or it's not.
Jeff,
You're setting yourselves up for an arbitrary.
Why is it not compatible in a multifamily dwelling? What, are they second-class citizens or something? I mean, if we're protecting the single-family residencies and basically allowing it in the multifamily dwellings, it sort of pushes it towards them. And if it's a problem for the single-family ones, is it not a problem for multifamily dwellings?
Well, I
That's
was,
a
I was
valid point.
interested to read that Texas case Draper versus Arlington.
Jane, can you get to the microphone, please? Thank you.
Sorry, Draper versus Arlington. And in that case, the city of Arlington had done a bunch of research, and they made some legislative findings. And in that city, apparently, they have a bunch of sports stadiums in a particular part of town and other entertainment venues. And what they ended up doing was drafting an STR ordinance that said, that created a new zone around the entertainment district. It said, within a mile of that, or whatever it was, I don't remember exactly, because that's where the entertainment venues are, because if it's within a mile, people can walk to it, and that probably is going to reduce the traffic around the entertainment stuff anyway. And because it's already the entertainment district, so there's already a bunch of hubbub and so forth, and it's not the same disruption to a neighborhood, even if it's zoned single family, that it would be in a district that's farther away, that does not have the proximity. And so they articulated the reasons why in some areas, and they did the same thing. They said multifamily, you can have SDRs in multifamily. What we're trying to separate out, and again, they articulated a difference between life in a single-family residential district out in the suburbs versus life in a condo complex or close into town or in close proximity to the entertainment district, and said, here's the reasons why we're doing it this way. And I think that's what we would have to do. I don't think we can just sit here and say, well, we're going to let this one and not that one, and it's going to be some kind of arbitrary, shoot from the hip. That we shouldn't do. But I do think that we could, first of all, I think we do need, whatever we do, to look at the facts that we've assembled, and we need to look at the purposes of zoning and the goals, under our comprehensive plan and the purposes of zoning under the PDO and all those kinds of things. And then I think we have to make some legislative findings. Because this is a knotty problem, okay? And we have to make some legislative findings in order to, I don't know if justify, but explain how we got to where we ended up. But I think we can paint with a little bit finer of a brush if we do that.
Yeah, I agree. And I wasn't saying those types of approaches should be thought of as being completely off the table. I'm just cautioning you that what you're describing needs to take place. We need to be able to articulate very clearly the distinctions and why.
Right. No, I've tried to take a crack at that myself, assembling
Jeff, what do you mean
information and goals and
articulate
stuff.
the
but-
distinctions? We need to be able to articulate the distinctions. What,
Lydia, you're going to have to get close to
I'm
the
sorry.
mic.
We
Bring it up
need,
to you.
you said we need to be able to articulate the distinctions. What do you envision?
I specifically, you will have adjudged that it's acceptable in one single-family area, but not acceptable in another single-family area.
Well, you know,
But
communities.
for example, I mean, you might think about downtown, right? Downtowns they're more bustling, there's more activity, there's more people, there's shoppers, there's pedestrians going to and fro all the time, there's more late-night activity, and we have single-family development that directly abuts downtown. There might be an opportunity for an overlay there, or something that says,
Could be.
here, it's okay, because it's part of the life pattern there anyway, so,
Yep.
to your point, yeah.
I would agree with that. That might be a
Yeah.
way out. I think, look, communities make distinctions all the time
Yeah.
as to what they want to have in certain parts of the community. It's just the nature of how towns and villages and cities have developed over time. And if the village of Pinehurst thinks that for the residents of Pinehurst, the quality of life of the community we live in, that it is a decision that's wise to restrict certain types of short-term rentals, there are very few in the village of Pinehurst, based on the number that we really aren't sure of, but we have a good approximation of 400. And we have a very good approximation of 9,400 that are not short-term rentals, that are residents. So I think the village is playing within the 40-yard lines of the authority and responsibility it has. And I think we're like other communities around the country that make distinctions regarding neighborhoods. You can't have a restaurant sometimes in a retail area. I mean, these things happen all the time. And I don't think what we're discussing is anything sort of drastic regarding short-term rentals.
Patrick, we started the conversation, I don't know, 3 months ago, 4 months ago, as to when we started here. The vast majority of people who came up to the microphone were saying, we're not supporting a ban.
Yes.
We want to be able to basically correct the bad actors, to make sure that we're doing it. Well, what's evolved now, at least from option 3, if that's what it goes into, or from the draft that you've proposed, that is a ban, okay? And that's a ban there on single-family resident districts. And when you talk about you're being in the 40-yard line there, or being within the 40, however you want to describe that for football, basically that's not that drastic. I got to tell you, I think it is, because right now we're in a situation where even Jane just mentioned about, compile the facts. I'd like to see the facts that we have, okay? Because I don't think we have a whole lot of facts. I think a lot of it is opinions on there. I know there's frustrations in it, and I'm very sympathetic to that. I started from the whole conversation, I'm sympathetic to that. But we've got some legal issues here, and I'm not the lawyer, okay? But you're talking about taking away people's property rights because it's an aggravation to the community. And I understand as a community, we can do zoning type of things. But with that, you better have the due diligence on there that you've really looked at it and you've looked at other different ways to do that. And I can't say we've done that. I'd like to see the facts that we have.
I'm for acquiring more facts and more facts and more facts. I just don't want to fact ourselves to paralysis.
I got it. I also,
Okay.
I don't want to lack of fact us that we take us to court and we end up spending a bunch of tax dollars defending ourselves
Well,
as to what's going on. And that's right now what I'm saying.
Decisions we make
Go.
as a council always have the possibility of us going to court. But
Okay.
if the threat of us maybe going to court determines us not taking action, then we are not stepping up to the plate on behalf of the residents of the village of Pinehurst. And that's the way that's the way I view it. And by the way, on the banning, I'm always opposed to banning short-term rentals all across the village. I've been that way from day one. I am for banning or restricting them in single-family residential ones, just like they do in Pine Wild and some other communities.
Patrick, you were at senior levels in government, okay? And I can tell you when I'm making decisions on the organization that I'm leading in there, we go through a thought process that mitigates risk.
Absolutely.
To cavalierly take risk that you don't have to take is irresponsible.
Yeah,
And
absolutely.
I think that that's what's going on right now because you haven't mitigated the risk here. We just heard from someone who's going to probably take us to court if we're going there.
That's
okay?
my point exactly. My point exactly, that someone suggests, I'm going to take you to court, get ready.
That's
That is
exactly-
not the.
I understand that.
I don't, that's not the way I think a council member needs to confront somebody who's threatening that.
I'm not worried about court as much as I am losing. And my point on this is that right now, at the way it looks on here, they got a tremendous case. Now, I'm not a lawyer.
I'm not a
but
lawyer either.
We don't have the
then-
background on here to say they're good. You don't get into a fight that you know you're not going to win.
They may or may not have a tremendous case. I don't know. Matter of we have
Well,
some.
there's a whole lot we don't know.
There is.
Okay, and then we have to be careful on how we're making decisions there. That's back to risk mitigation, which is a responsibility of leadership.
It is a responsibility of leadership, but so is the responsibility of to do what is the right thing, even if there is some risk. We can't be so risk adverse that someone says, I'm going to take you to court. Oh my gosh, change my mind. Let's do something else.
Okay, well, the right thing is to try to ameliorate what's going on in the bad actors. That's what we started this with. Okay, we've been given different options on there. It's not just simply it has to be a ban.
All right.
Well, a ban is one proposal. The other, nobody else has come up with the silver bullet. They've been talking about this for years. There was a meeting in September of 2018 that the Partners in Progress held with short-term rental owners and hotel owners to try to come up with some solution. They left with no
Well,
solution.
someone just talked tonight about results-based management. Okay, talked about voluntary compliance.
Also talk-
And they go, yeah, okay, that's react. But come on, you haven't even tried it.
Wait a minute. That's the same person who said that property values would drop 11 to 18% in the first year in Pinehurst if we
Correct.
adopted
What
that.
was he referencing?
What was he referencing?
Yeah.
Your guess is as good as mine because I've never seen the study.
Okay, well, why don't you look at him, ask him, because he's the only guy who's talked here about having peer-reviewed articles.
Does
he's
anyone
referring to.
have the study?
Academic articles.
Have you
Okay.
seen the study of 11 to 18% decline?
All right.
No,
hang
I've
on.
not seen this study.
Gentlemen, hang on. Okay. We've got good ideas.
It's a good debate.
You're concerned with risk, I think we all are, and having the data to support whatever we choose to do. And it's going to take some continuing time to do that. And as we heard tonight, I encourage Mr. Sunia to supply us with the information he was talking about tonight. I hope he has that in a way to do it. Now, where we were on this, though, was trying to work with Darren about two options. And what I heard last meeting was item number 2 and what we called 3B, which is the underscored red line there. And then I asked for clarification from Jane. My notes show that we were adding the wording in there, and Darren, you may have this. We wanted to make clear we were allowing short-term rentals in multifamily and mixed-use districts. Isn't that true?
Yes,
All right, so
that's
that's not on here.
That's correct.
But that's one of the things I think that helps to mitigate risk, although there are some other issues at heart there. I understand that. All right. If we show we're not banning, and we're not, but we're allowing them in other places. So, and that's the important add I was trying to get to earlier on your comment. All right. So, if that's consistent, we have two options in this matrix. Number 2, and what we'll call number, again, 3B, which is the red underscore with the multifamily allowed in mixed use and other districts, right? So I would like us to focus on those two options. We know we have a draft of another approach to this, or I think it's really information about how an ordinance might come together, which we need to turn over to staff to work through.
Staff, you're referring to the draft ordinance that's on the website?
Correct.
Yeah, and the staff
Correct.
has it.
Correct.
And the reason that was drafted is so that we would have a draft ordinance to think about. And so I'm looking forward to anybody's input. It's on the website, and I've had a couple of people already give me some suggestions and edits of over the transom, shall we say. So I look forward to that
Now,
discussion.
Do we agree, though, that we have two options on the matrix? We know what they are, we know what they say, all right? Okay? And there's been a draft prepared, Pat, you were involved in that, as a way to prompt this discussion and as a way to focus on all the issues that might come up. Now, the draft of any ordinance we would want to proceed with has got to be done by staff because they're going to know how to cross-check and all the issues that would come around there. But there's quite a lot of material in that that's probably in the matrix more or less, but it does give us a focus paper to deal with. So do we agree we have the two land use purposes in the matrix? Is that describing it in ways that everybody's comfortable with? Because I want to get to the point of approving one or another of these, at least in theory, so that the staff can start looking at the way a draft ordinance would be done, but also continue this process of getting some data that we all know we need to work through on this issue.
Yeah, I agree.
Okay. Well, I'm not hearing any further discussion on the two options from the matrix. So why don't we turn, unless, Lydia, do you have a point on that?
So what are we doing with these two options? I see them,
These-
and they're two different
They're
options.
two completely different approaches to short-term rentals.
So what are we doing with them?
I want to come to the point of discussing that, comparing it, or getting some direction through this draft, and then making a decision on which of these two options we want the staff to begin to draft up an ordinance that would be applied with that guidance.
Okay, and I wasn't a fan of the threat of litigation, but I take litigation very seriously, and I even looked in our SOP notebook, and we talk about how we assessed all risk, including risk of litigation. If we decided to go number 3, I would hope that we would have what we thought would be a bulletproof position.
Right.
Working with our attorney, having all of our, as Jeff said, facts, have our compelling reasons and the facts supporting those compelling reasons. But to go number 3, I do think subjects us to more litigation risks than number 2. So I would want us to be very, very prepared if we decide, if the decision was made to go that route. I think it comes with tremendous litigation risk.
Location risk?
Litigation.
Litigation, sorry, thank you. All right, all right. Now,
Again,
Jeff?
and you have your semantics on there about saying it's not a ban. It is a ban in single residential areas. Okay? It is a ban there. And if you go that route, you're going to hurt Pinehurst. Okay? You are going to drop property values. You're going to hurt tourism. You're going to hurt the downtown shop owners. And I think you're exposing us to litigation here that we very potentially may not win. Okay? So I think you're going the wrong direction if you're going number 3. I would recommend that we go number 2 and do it with enhanced standards and regulations, use municipal ordinances to try to do that, get a voluntary program going to try to bring in the bad actors. That is the recommendation Jeff Morgan provides to the council.
Can I make a recommendation?
Jeff?
In the interest of moving forward, I think it's fair to say that all of the actual regulatory actions that we would take under 2, we would also take under 3. Maybe the best approach is to direct us to start with the number 2 regulatory things that we would put in place and start drafting that language
Jeff, doesn't
while we're building more information.
the Wilmington case allow us to do that? The Wilmington case toward the end discussed things that you still could do, which I interpreted as the enhanced standards and regulations.
That's right, yeah.
So that's permissible under the Wilmington case.
The things that are much less controversial.
Which the owners and managers of the short-term rentals seem to be willing to accept. I haven't met with them, I haven't talked with them in a while, but
Except for the permitting part, but.
Yes.
I would also, I've made this point before, I think that we can, with regard to permitting, we could take an approach that's very safe. And in order to do that, you just identify the permitting requirement in your development ordinance, but don't make anything else reference that permitting requirement.
What's the difference between permitting and registration? Are they interchangeable terms, or?
Well, maybe Darren's a better person to answer the question. Before we started having this conversation, I couldn't wrap my head around what a registration was from the standpoint of land use. Permitting is pretty easy for us to understand.
Correct. I would say, I see registrations that similar to licenses. There's something that you can, you typically, a lot of times there's a period built into them, like a lot of the registrations with respect to short-term rentals would expire annually. So they would expire. Then you had a couple of the communities that were actually kind of using the zoning permit like a registration and expiring it annually. Usually when we issue a permit, a development permit, it's a one-time thing. So it's, you're coming in, you're telling us that you want to build a single-family house, and you meet all those requirements. So that's when we issue your development permit. You don't get another development permit until you come in and want to do something else. I want to put up a fence, I want to do this. So from our standpoint, our thinking with the permit simply would establish that use, and it would make it legal, and we'd make sure it met all the requirements. A registration is something that I've seen that happens more frequently in rental instances, and something that just turns over yearly. That was not our idea when we started down the permitting process.
We make sure that we understand what the General Assembly means by registration. Because if,
No?
no,
Isn't clear up there. It may not be clear down here.
because if registration just means keeping a list of the names of the owners and addresses of short-term rental properties, then we almost can't do anything.
No, that's not what it's mean. The restriction isn't on having a list or a registry. It's on requiring short-term rental owners to register, which is a different thing. So, for example, if we wanted to put out an information call from all of our residents to say, tell us where all the short-term rental properties are. In theory, we could build a registry that wouldn't violate the general statutes.
Is the act of somebody coming in to get a permit registration?
Well, that's the question that I think the Wilmington case appeals court left on the table.
Because if a local government is not able effectively to regulate short-term rental numbers, proliferation, occupancy, which seems to be a big component of bad acting. You get too many people stuffed in a house, and you get the noise and all the other stuff. Effective if we can't make sure that short-term rentals are well managed, which we can do with not necessarily the village would do, but a hotel or a B&B has got some management standards in place. And if we can't enforce safety standards for the benefit of the tenants, making sure that there's smoke and carbon monoxide detectors and those kinds of things, then we can't do what Jeff is suggesting, which is what I'd like to get to too, which is to have reasonable regulation of these uses, which I distinguish from ordinary residential in that they're transient occupancy. And of course, we have a list of transient occupancy uses now in our PDO. And I don't believe it's taking away property rights, because if I have a building in the residential zone, I'm not allowed to use it as a hotel. Hotels aren't allowed to be used in residential zones. How can I get around that de facto by leasing? Doesn't work for me. And you look at the definitions, and I know I'm getting off track, and I apologize, but you look at the definitions in the PDO for dwelling unit, single-family dwelling, dwelling, comma, single-family, and they all, a lot of them say, or a couple of them say, that there's a rental element there, but they all say for the purpose of living there, which implies to me long-term living and not transient occupancy. But anyway, if we can't effectively regulate the operation, then the only other thing we can do to protect the residential neighborhoods that aren't down by the Buzzin Village Center, that are where people have retired to, and where people have an expectation of quietude and repose, all right? The only thing we can do there is prohibit on a zoning district by zoning district basis, which again is painting with a much broader brush, but that's the only protection we have left for our residents.
And what you didn't say, but I think what you were talking about, or what you mean, is that if we can't have a permitting requirement or a registration requirement, then it's difficult for us to
Correct. That is the
manage all this.
thrust of our ability to address this problem.
So going back to my earlier point, if we crafted the regulatory approach with all these other things below 2 and 3, right? That we all kind of agree on as approaches, and we also enacted a permit requirement, well, okay, we heard from the community that they're willing to take us to court. You know, they're gonna.
They can take us to court about anything. Doesn't matter.
And I don't think that's an idle threat. I think I think they're telling us their position, but I think that they would be a lot less willing to get into a knock down, drag out court fight with us over permits than they would over amortization. And even if they did, and even if the courts found that our permitting requirement was in fact not legal, then we're no worse off. They strike out the permitting requirement, we still have these, and we're back to where we are right now, and we can continue this while we're building information, right, and data, and
So Jeff,
yeah.
simple. Okay, we would, an ordinance said everybody with a short-term rental has to acquire a permit. And is
A
that
zoning
what
permit.
Yeah.
A zoning permit.
Yeah.
And you said while we're trying to get the other stuff ready. So if we did an ordinance that said you have to get a zoning permit, and that's all it said, does that expose us to legal risk?
Yeah, maybe they might take us to court over a zoning permit, but it's like, this is very minor stuff then, you know, nobody's losing business because of it, there's no financial loss. It's
And
just
the
just this technical requirement of a zoning permit.
And the reason for requiring a zoning permit would just be so we would, what would we be trying to accomplish?
It enables all those other regulatory activities that we want to try to accomplish.
The occupancy caps, the parking, things like that.
Yeah, I'm just trying to think through, I'm trying to think step by step. Okay, required zoning permit. Okay. And then the next step after that is it all in one ordinance, or is it a series of ordinances?
I think, Lydia, that there would have to be some zoning regulations in the PDO.
Right.
But there are other provisions, such as not parking overnight on streets in single-family residential neighborhoods.
That'd be municipal code.
That would be municipal code. So I think there's going to be some of each. Can we put a moratorium on new STRs?
We've looked at that question a couple times. We've not found any examples, I don't think, of moratoriums on use. Moratorium is a restriction on development.
But you're talking difference between a temporary moratorium, which what we're doing sort of in the small area plans, versus a permanent moratorium.
Well, you can't do that.
Can't do that.
Yeah.
But just the same as opposed to the discussion we had on caps, which we had 3 or 4 months ago. I'm not a big enthusiast about caps, but you know what? Caps wouldn't be bad. But you know what? We can't do that because we can't register them. How can you cap something you can't register?
Yeah.
Right. Or
That's why
a
we.
permit or something,
That's,
yeah.
or permit. That's why we go back to the authority that we actually have, which is that zoning ordinances. That is the one authority we still hold as a village. Wilmington took away some things, said you can do other things. The short-term rental community would have been much better off had they allowed for registration. Because then we could have negotiated around the registration. But that's off the table.
Right.
So we're left with the vehicle we have that can help us protect the quality of life for the residents in Pinehurst. And we're dealing with very few short-term rentals. And yes, it's grown, but it's very few compared to the 9,400 residences that are not short-term rentals.
We had healthy debate here about risk, right? And
Yeah.
Our obligation to manage and mitigate risk. There's another risk on top of the legal risk, and that's the risk that the General Assembly
Absolutely.
doesn't like what we do and strips not only our authority, but the authority of all of our
Well.
other local governments across the state of North Carolina based on what we do. And we're no better off having had that happen.
Right.
So,
If we do
Another
nothing,
risk.
no,
we're.
Nobody's
we're
saying do
in that
nothing,
boat
though. That's
right
the
now.
point. So,
But-
yeah.
But to what extent are these regulatory items and on Darren's matrix and that, we've been looking at, and maybe there's a few others we can cobble together. To what extent are they just shreds and tatters? And to what extent are they effective? And I don't feel confident in their effectiveness because of the whole registration thing. If we can't make
Adopt
somebody
the ordinance
tell us
requiring
that
a
they're
permit.
operating a short-term rental, then
Adopt an ordinance requiring a permit, and let's see what happens.
And permits can be issued or not.
Well,
I've got a couple
Well,
things.
only on a conditional use basis, right, Darren?
For what? What part?
Zoning permits?
Yes?
My point was they can be issued or they can be not issued by the village.
Well, it would be an entitlement permit, so if you came in and you met all the standards, we would be required to issue the permit.
But if you issue a permit and somebody racks up a bunch of violations, you can't retract that permit, so,
Correct, we don't revoke those permits.
That's a big downside.
yeah.
So we really, we don't have the strongest stick in this situation then.
We do have relatively strong sticks when we do notices, where we do violations, fines. I mean, we worked on 2 STRs last week where we got some complaints on, and we were able to get a hold of the property owner and deal with the issue. So 2 of them got dealt with. But we do always have the ability to issue fines. And once the fines start to rack up into the thousands, that's when we have to move into potentially, civil action.
Darren, let's put some thought about this question of whether or not you can revoke a permit.
I know we can revoke special use permits, conditional use permits, but
I'm interested in that question. I'm interested in finding out what registration really means. Because right now, it's kind of it's a guess. And I'm interested in what is staff's idea of a reasonable length of amortization. And even if it's a range. I mean, I've made inquiries in the past at the School of Government and gotten a range, but I'd like to hear what you can tell us. And I'd like to have a better understanding of how enforceable this list of items really is if we don't have the ability to require registration, or if a permit can't be revoked. I mean, what can we really do? Now, one of the pluses, if we create a bunch of nonconformities by banning on a district-by-district basis, even if we didn't amortize, Section 2.3 of the PDO would come into effect, and that's the section that tells how nonconformities are treated. And first of all, you have to qualify to be a nonconformity, which means you have to demonstrate that you were actually engaging in the use in a lawful manner prior to the new rule. And then there's a list of, there's no enlargement, extension, or intensification of nonconformities is permitted. Maintenance and minor repairs are all right, but if the building is destroyed by 50% or more of the replacement cost, that discontinues the use. And if the use is changed, it can't be changed back, and the use can't change to a different nonconforming use without council okay. And also, if the use ceases to operate for a period of time, that's an act of discontinuation as well. And the standard one in section 2.3 at the moment is cessation of use for 120 consecutive days. But there's also a secondary rule that was put into effect for banks and financial institutions in the village commercial zone, and that's cessation for 30 consecutive days. So presumably we could say cessation for a certain number of days. And that way there would be a certain amount of control if we didn't have amortization, let's just say. But we banned on a district by district basis. We would still have control under 2.3 over the nonconforming uses. And there would be a natural, what's the word I'm looking for? It's not atrophy. They would naturally, over
Amortize.
time. Yeah, there you go. Sorry.
Capital moves.
I think what you'd find, though, is the use would be very durable.
So maybe we could get some answers from staff on these 4 or 5 questions, which would be helpful.
You made an interesting comment there that there's a spin to. If you ban in districts or multiple districts or across the village or whatever, then the existing nonconformities would have to demonstrate their existence. By doing so, they have allowed us to create a registry.
Create a what, Jeff? Create a registry.
A registry. Now we know where they all are,
This
right?
is the kind of circular
And we
thing
can manage
that
them
is
all.
happening.
So that's a whole different approach that,
Another, I believe is the correct term.
huh?
A whole nother,
Another?
yeah. But this is the problem. Every time you try and think of how to manage in a reasonable way under the regulatory authority we have, we get tripped up with something, so.
That's why the approach to the zoning is the least Rube Goldbergish approach that we could take. It's sort of the most transparent for our residents as to what we're doing.
Right.
They're concerned about growth of these, okay? I don't think they're actually
It's true.
appalled or repulsed by the concept of a short-term rental. I think there's some. I found that out. There are some. But I'm not, okay? Short-term rentals, they happen a lot, but it's a question of where and how many. That's what our residents are concerned about. They're not sort of searching for these short-term rentals. The reason, as I said before, the reason we're here discussing this is not because the short-term rental community asked us to come up with something. They haven't. We're here because our residents who don't have short-term rentals came to us and said, there's a problem. These things are growing. There's no control over them. Now, here's the advertisement, Sleeps 15. This is the house next to me. We heard from a variety of residents, Pete Green, we heard from David Byers. They all have interesting individual stories of which we should not be making policy about solely based on those stories. They should be factored in to what is the wisest decision for the overall quality of life for the residents of Pinehurst. That's why I'm for restricting, banning, whatever the word you want to use, in single-family residential areas, because that's where the problem exists. That's where the complaints come from. In the multi-use, the multifamily, mixed use, I don't hear anybody saying to me, boy, that apartment above me, you won't believe what they did last week. But someone who lives in a residential area will send me photos of the RVs that are parked on the side of the street. So that's why, as we keep discussing these, and they're very clever ideas, registration versus permitting, you know, I guess it's one of those things the lawyers will play with for a long time. There's other ways to do this through nuisance, what generally referred to as nuisance restrictions. But there's nothing that is so clear and actually puts a marker down as to the community we'd like to be than one that has us as a village utilize the municipal code, and the one thing we've been told we still can do, and see what happens. Risk's involved with everything. I totally agree with the lawyer, the doctor. But I think the risk is worth the reward, and I also think the risk is worth a response to our village residents for us to take some sort of action that's clear, concise, and responds to what many of them consider largely, though not totally, commercial interests from outside our community that are purchasing properties and turning them into short-term rentals. Not all of us, but if you take the number 400 and you make a good guess estimate, I'm betting there's at least 150 of folks who don't live here. They live in, and why do I pick 150? Because I received 134 emails from people all across the country that don't live in Pinehurst, telling me don't touch short-term rentals. Now, did I get some from people from Pinehurst? I did. Nowhere near that number. I've got new friends in Santa Monica, California, in Chicago, Illinois, Brooklyn, New York. And these are not people who come down here and have a skin in the game with us. They're not here buying cars and computers in our stores. They probably don't even visit here most of the time. There's nothing wrong with that. They're investors. They're capitalists. And what capitalists do, if an economic situation changes where they have money invested, they move their capital. So I think, and that will open up homes for people to live and to purchase who actually want to live here. That's all I got.
I have to say that after months and weeks of listening to dialogue and coming up with ideas and solutions, I don't see this situation being resolved unless we do something to prohibit in single-family neighborhoods short-term rentals. I think we need to consider allowing them, which is why I added that phrase, in multifamily and other districts. I would like to see, as a part of the process of drafting an ordinance, how concepts like overlays can be used that might affect this in a positive way. I think Jane was speaking somewhat on that way with the information you had from Arlington, which I have read and agree with. But I just don't see at this point any other alternative, really, other than to proceed to try to prohibit in single-family neighborhoods. I've looked at the economics of it. I think we need to get more data. I think we need to look at that. Information tonight was suggested is available. I hope that we'll get that. And I'm happy to consider to look at all that as we progress along drafting and looking at an ordinance. So that's my position on it. I don't know if the information that was in this draft ordinance that we got is of any comment or question or useful in sort of laying out the general terms of how an ordinance would read. Does anybody have any questions that we want to talk about on that as a guidance to all of us and to staff on how to proceed? What needs to be contained in that ordinance?
I think we've had a lot of the conversation just talking about 1 and 2, because that's effectively what the draft ordinance is. It's the ban in single-family resident areas. And so,
What I meant by that, and not to interrupt, was that there's a preamble there. There's a setting of tone that I think is very important. And it's some of those things I think we would try to incorporate in what we do going forward. I think that's very, very helpful. And then some of the specifics on the regulatory issues are very common to what we already have in the matrix.
By the way, thank you for mentioning, the preamble sort of lays out the predicate, as preambles often do in federal rulemaking. And with the exception of that section on the banning in single-family residential areas, there is a section on safety and operational regulations. There's a
I read it. Yeah.
voluntary registration program. I just, for other people who might be listening, there's a listing of definitions, and there's an enforcement and penalties, which touches on these other things we've talked about, parking and so on. So it's not long, but it is somewhat comprehensive in that it touches on just about every topic we've mentioned in one way or another in the last 4 months. But it obviously it needs comment and work from the people who do it full-time.
Needs more,
Well, it's got to be done appropriately, but it's a start.
what you're going to draft ultimately is not a standalone ordinance, which is what you, I think, tried to draft there.
Yes.
You're going to draft a series of text amendments.
Yeah.
Minimum of 2, one that pertains to the municipal code and one that pertains to the development ordinance. And it's going to line by line with paragraph identifiers talk about, where's the context of what we're looking at here, what's being removed, what's being added, okay?
The planning
My
does.
point is, let's focus on what you want us to do, and then let the staff draft the ordinance. That's what I've been saying. Along those lines, and consistent with a comment I made earlier in this conversation, 2 is a subset of 3 in terms of the provisions that we need to draft. And beyond that, some of 2 is PDO and some of it is municipal code. With your permission, the direction I'd like to give staff is to start with the municipal code. text amendment development. When we get that matured, bring that to you. There might be some iterative stuff going there, but then we can start working on the development ordinance things that are too specific. While we're fleshing out our understanding, gathering data, other information, and then in the end, when or if you choose that 2 is ultimately the better, or 3 is ultimately the better option, then we layer on that last piece. That's the most efficient way, I think, that we can use our staff resources to move this forward.
I think that's an excellent outline, Jeff, of how to proceed. I like that. It keeps us moving, but it keeps us being able to, gather data, analyze the data, figure out where we're going to end up. But I think that's a very logical way to go. I do.
I concur with it. I concur with the statement. It's logical.
Questions on that? Or?
Yeah, I'm still, have somebody here from CCNC, and I know they have a very well-run short-term rental program that's meaningful to the community. And it sounds like from what I'm hearing that what we're doing might end their successful program.
Lydia, if you keep your finger.
I'm sorry. It sounds like, it sounds like what we're doing, I was thinking. It sounds like what we're doing, but CCNC has a very good short-term rental program, and it sounds like what we're doing could jeopardize that successful program.
They do have a good program, and when drafting up this ordinance, under the applicability section, we factored that in so that it could continue. And if it needs stronger wordage, we can have stronger wordage. That's what's...
Well, and as I said before, I think we may have some differences of opinion on this, but I do think that in the gated communities, private communities, be Pinewild, CCNC, Cotswolds, number 7, I think we do need to take account for policies that they already have been
Yes.
operating under and not get involved in trying to affect that.
I agree.
So we'll proceed to develop the, what do we call it, the municipal code versus the PDO approaches that are contained in,
Text amendments.
through the text amendment process, that are contained, kind of outlined in the whole of the matrix, everything beyond 2 and 3.
Well, not everything, but some of them are, and then some of those regulatory approaches are still PDO approaches. But
Yes,
focus on municipal code, then do the regulatory side of the PDO stuff,
right.
and then we can address this 2 versus 3 thing.
Okay, well,
when
at
we have
least
more information.
some of us have expressed our view at the moment as to where we stand on that. But I do like the preamble idea. I think that's really important here, and it helps build the case for why we're doing the things we're trying to do. And Jane, I think, spoke to that a bit earlier as well, about that, the need for that sort of case building, which I think has been very helpful.
And as we gather more data, the stronger.
As
we
we
can
have
make
more
that
data,
preamble.
that will become stronger.
Yeah, I'd also like to endorse or lend my support to the suggestion about some overlay possibility if there are certain, I'll call them homes, who border back into a commercial district, but they're in a residentially zoned one, that there ought to be a way to see if we can
Yeah.
make that work. Because
like,
if they've been short-term rentals for 50 years, I mean,
Yeah, it's kind of like a permutation on a highway corridor overlay.
okay.
Yeah,
I didn't think of
certain,
that.
certain things that are okay if they border a commercial district type thing.
Okay.
Yeah.
We did explore that as an option. That was option number 5 on the matrix. So we did talk about creating a floating overlay district where SDR.
Darren, your microphone, please.
We did create that as an option for number 5 on the matrix. The
Yes.
floating overlay.
Yeah. Overlay defined in new ways, we may have to. Good. All right, are there other comments for staff now from this discussion on short-term rentals? And the direction I think we've given them Jeff's been asking us to do that. I think we've come to the point of being able to do that and progress this along. And we do know, again, there'll be other information, data that we want to have to work through this. Okay. That'll conclude the short-term rental update. I have 2 comments I'd like to make on other work session business. Does anybody else have any other work session business from the council to mention?
No, I don't know if we want to do it now or next meeting when we take the final action on the budget, but on the policy of the 30% versus some.
Well, isn't that that's an agenda item. If we.
Yeah, I think we need to
talked
bring
about this
that-
before, that's an agenda item.
We need to
Yeah,
bring that back.
I think what I would recommend, if you want to
What's
have
your
that
suggestion?
conversation, we'll put it on a future agenda.
Fine.
We just did this about a year ago, almost exactly a year ago.
We did,
So
yeah.
we can rehash all that.
Thank
and
you.
update that information.
I'm fine with that.
Yeah.
Well, we might just go and get the minutes of those meetings. And make sure we're all up to date on that.
Yeah.
My 2 items are just on information, really, or one question. At our budget retreat, SOP, we had quite a discussion there at one point about the track and publicizing the track and working on some marketing for that. And I think Mark and Jeff are going to go off and work on that. Have we progressed on that? You don't need us to do anything because we already gave you your permission. But are we going to take advantage of some of these activities out there and promote ourselves in Ohio and Pennsylvania, et cetera, et cetera? What are you laughing about?
We already were. Many of those things you heard, we already are doing, but,
Okay.
yeah.
Just,
And fixing up some of the facilities. Go ahead,
I
Pam.
was going to say, full disclosure, I'd asked for a meeting next week with Mark to get a little more deeper dive, so I understand what's going on there in Parks and Rec and the harness track and so forth. And one of the things I was thinking about is that I almost thought last week or whenever it was, when was it last week? When we had our budget
It was
briefing.
last week.
When Mark was talking a little bit about how much this cost and how much that cost to fix this and do that. I left that thinking, I think he's being, it's always good to have a stingy person who's in your government, but I think he was being stingier than I would want him to be. I'm supportive if it's, instead of 7,000, it costs us 15,000 to do a couple of these paddocks. If we can do them all, we've got this cash right now. And these are, capital, small c in this case, I guess, some of it, investments. But I would rather not, and I'll discuss it next week, I don't want to nickel and dime this. I think if we can have a little burst of money, I'm not talking about, going off the rooftop, but I'm just saying, let's not try to do 3 a year. If we can do 9 a year, and it costs us a few more bucks. So.
Does it help to set a dollar,
That-
give him
was
does it help to give him an allowance?
Well, I don't know, I want to
Well,
hear more.
that's what the budget is.
Well,
Thank
he's
you,
got a
Jeff.
budget, but we're now saying we want to give him a little, knowing that some horse tracks are closing down in Florida, and there's the possibility we can get more. Can we give him a little more and tell him, this is your allowance? Or, I
Well,
mean,
you do budget amendments, right?
you don't need to.
Right, yeah, and I think where we left that conversation
To spend
off
more
the
money.
last time we talked was, let's get let's get the budget adopted. If we want to come back with
Right.
a budget amendment for something like that, we can do that. And I think that also pertains to a suggestion I think Lydia made about maybe ramping up our walkway
Yes.
allocation,
Yeah.
if you guys are amenable to something like that.
Right.
If we come back in July or August and say maybe it would be more appropriate to bite this off in bigger chunks,
BPAC would like that.
Okay. Good. When you have that meeting, would anybody like to
Yeah,
join
everybody's
Pat?
invited.
I will if nobody else
It's
has the time.
scheduled for next Tuesday at 2:00 at the community center with Mark and Jeff.
Okay, we'll work on
Jeff.
that. So at least a
Saw
couple
that.
of us can hear that. Pat has a meeting with Mark Wagner, 2:00 next Tuesday, a week from today. If anybody wants to join that, do it. If you're not, I'm going to do it myself with him. So we'll talk about that. Maybe Mr. Morgan can come over on that day. It's the day after a holiday. He's got to work. The other thing I wanted to raise was this. The Tin Whistles and the resort are in discussion about hosting a golf tournament, Donald Ross Golf Tournament, Hickory Tournament, on November the 3rd, which combines into a weekend of other Hickory golf tournaments that will be in the area at that time. It's similar to what the library did last year, but it will be handled by the Whistles and the resort. Looks like it will happen. I think the only role that we can need to play in that is just help with some publicity and distributing that information as they develop a plan. And that's we didn't want to get involved in managing that, so they're taking responsibility for that. Just an update.
Will we have an opportunity to have a mini closed session, or do we have to post that? Okay.
Session for what?
I had a question, a follow-up from last meeting about something. Maybe I
I
can
think we have an obligation to
post it. Don't worry about it.
publicize the purpose of the closed session, so.
Right.
No problem.
Now, to
Not urgent.
that point, I don't think there's anything that requires us to have it on the agenda or publicized to the public, but you would have to make a motion that has the right language right now.
Okay. My topic is neither that sensitive or
Yeah.
urgent. It was just something that had come up, and I wanted to
Okay.
get a follow-through, that's all.
Yeah.
Well, maybe we work that into our next meeting then. Be in touch with Jeff on that. All right. Any other business?
All right.
Any other business for the council tonight? Seeing none, is there a motion to adjourn the work session, please?
Seconded.
Motion by Lydia Bosch, seconded by Pat Pizzella to adjourn the work session. All in favor, say aye. Aye. Any opposed? Thank you very much. The work session is adjourned.